on our electoral democracy.
We appreciate Manoj's.
That is outside now. Outside, my lord.
No.
Press. The photographers are outside. You are saying this at wrong place. Obliged.
Deeply obliged, notes.
We have arrived at a unanimous verdict in the challenge to the electoral bond scheme and the amendments introduced to the provision of the income tax, the Representation of the People's Act, and the Companies Act, and the RBI Act. There are two opinions of this court, one authored by myself for Honorable Justice Gawai, Justice Pardiwala, and Justice Manoj Mishra, another authored by Honorable Justice Sanjeev Khanna. Both opinions of this court arrive at the same conclusion, though there is a slight variance in the reasoning which has been adopted. The present batch of petitions raises the following issues. A, whether the non-disclosure of information on voluntary contributions to political parties according to the electoral bond scheme and the amendments to Section 29C of the Representation of People's Act, Section 182(3) of the Companies Act, Section 13 (A) of the Income Tax Act are violative of the right to information of citizens guaranteed in Article 19(1)(a) of the Constitution, and B, whether unlimited corporate funding to political parties as envisaged by the amendment to Section 182(1) of the Companies Act violates the principle of free and fair elections in Article 14 of the Constitution. I will now proceed to read out the reasoning and the conclusions. Issue 1. Whether the right to information guaranteed by Article 19(1)(a) includes the information of financial contributions made to political parties. The jurisprudence on the right to information, which has emanated from this court, can be classified into two phases. In the first phase, the focus of this court was on the close relationship between open governance and information. The judgments in this phase were premised on the principle that the citizens have a duty to hold the government of the day accountable for their actions and inactions, and they can effectively fulfill this duty only if the government is open and not clothed in secrecy. In the second phase, this court recognized the importance of information to form views on social, cultural, and political issues and participate in and contribute to discussions in the polity. A crucial aspect of the expansion of the right to information in the second phase is that the right to information is not restricted to information about state affairs, that is public information. It includes information which would be necessary to further participatory democracy in other forms. The ratio of the judgments of this court in Association of Democratic Reforms and People's Union for Civil Liberties is that the voters have a right to information which is essential for them to cast their votes. The ratio of the judgments is not restricted to information about candidates. Political parties are a relevant political unit in the electoral process. This is evident from the provisions of the 10th schedule of the Constitution, the Election Symbols Reservation and Allotment Order 1986, the Westminster form of government, which confers importance to political parties, and the electoral culture in India, such as the publication of electoral manifestos by political parties. The information about the funding of political parties is essential for the effective exercise of the choice of voting. One of the factors which contributes to political inequality is the difference in the ability of persons to influence political decisions because of economic inequality. Economic inequality leads to differing levels of political engagement because of the deep association between money and politics. At a primary level, political contributions give a seat at the table to the contributor. That is, it enhances access to legislators. This access also translates into influence over policy making. There is also a legitimate possibility that financial contribution to a political party would lead to quid pro quo arrangements because of the close nexus between money and politics. Quid pro quo arrangements could be in the form of introducing a policy change or granting a license to the person making financial contribution to the political party in power. The electoral bond scheme and the impugned provisions, to the extent that they infringe upon the right to information of the voter by anonymizing contributions through electoral bonds, are violative of Article 19(1)(a). We have applied the proportionality standard to determine if the infringement of the right to information is justified. Issue 2. Whether the infringement of the right to information of the voter is justified for the purpose of curbing black money in the electoral process. The right to information under Article 19(1)(a) can only be restricted based on the grounds stipulated in Article 19(2). The purpose of curbing black money is not traceable to any of the grounds in Article 19(2). We have applied the subsequent prongs of the proportionality standard, even assuming that curbing black money is a legitimate purpose for restricting the right to information of voters. Immediately preceding the financial year 2016-17, in which the electoral bond scheme was introduced, 81% of the contributions, rupees 580.52 crores, were received by political parties through voluntary contributions. Since the amount of voluntary contributions is not regulated, it allowed the circulation of black money. However, after the introduction of the electoral bond scheme, 47% of the contributions were received through electoral bonds, which is regulated money. The Union of India submitted that providing anonymity to the contributors incentivizes them to contribute through the banking channels. Assuming for the purpose of hypothesis that the Union of India is right on this prong, what it urges is that non-disclosure of information about political expenditure has a rational nexus with the goal, that is curbing black money or unregulated money. However, we are of the opinion that the third prong of the proportionality standard, that is the least restrictive means test, is not satisfied. The electoral bond scheme is not the only means for curbing black money in electoral financing. There are other alternatives which substantially fulfill the purpose and impact the right to information minimally when compared to the impact of electoral bonds on the right to information. On an overall balance of the impact of the alternative means on the right to information and its ability to fulfill the purpose, for contributions below 20,000 rupees, contributions through other means of electronic transfer is the least restrictive means. For contributions above 20,000 rupees, contributions through electoral trust is the least restrictive means. Thus, the infringement of the right to information is not proportionately justified for the purpose of curbing black money and electoral financing. Issue 3. Whether the infringement of the right to information of the voter is justified for the purpose of protecting donor privacies. Two issues arise for our consideration. A, whether the fundamental right to informational privacy recognized by this court in Justice K.S. Puttaswamy, 9 judges, includes information about a citizen's political affiliation. B, if A above is answered in the affirmative, whether financial contribution to a political party is a facet of political affiliation. The fundamental right to informational privacy recognized in Justice K.S. Puttaswamy, 9 judges, includes information about a citizen's political affiliation for the following reasons. A, forming political beliefs and opinion is the first stage of political expression. The freedom of political expression cannot be exercised freely in the absence of privacy of political affiliation. Information about a person's political belief can be used by the state at a political level to suppress dissent and at a personal level to discriminate by denying employment or subjecting them to trolls. The lack of privacy of political affiliation would also disproportionately affect those whose political views do not match the views of the mainstream. B, in the specific context of exercising electoral franchise, the lack of privacy of political affiliation would be catastrophic. Information about a person's political affiliation can be used to disenfranchise voters through voter surveillance. Voter databases which are developed through surveillance identify voting patterns of the electors and attempt to interfere with their opinions based on the information collected. For example, the data of online purchase histories, such as the books purchased, which would indicate the ideological leaning of the individual, clothing brands used, which would indicate the social class to which the individual belongs, or the news consumed or the newspaper subscribed, which would indicate political leanings or ideologies, can be used to draw on the relative political affiliation of people. This information about the political affiliation of individuals can then be used to influence their votes. C, at a systemic level, information about political affiliation could be used to engage in gerrymandering, the practice by which constituencies are delimited based on the electoral preference of the voters. Financial contributions to political parties are usually made for two reasons. First, they may constitute an expression of support to the political party, and second, the contribution may be based on a quid pro quo. The law as it currently stands permits contributions to political parties by both corporations and individuals